for legal text. So your name is Prosser. You wrote a book called Prosser on Torts. Well, you can advertise your book, because you're advertising yourself as a lawyer. So there was several years ago, there was, I believe it was Mr. Bjorklund, this Bjorklund case in 2006. He was an attorney, and he filed, Prosser on Torts and advertised that. So I'm going to write Bjorklund on how to beat a DWI case in Iowa. So he wrote this book, and he advertised it. Well, he didn't advertise the book. Prosser didn't advertise his book. The company that published the book did. So Bjorklund's publishing house, it turns out, started putting ads all over the state, or at least in his area, saying, buy this book, How to Beat a DWI Case by Bjorklund. By the way, Bjorklund is a really good lawyer. If you need somebody to take your case, you can go to him. The state caught wind of that, and they called in Mr. Bjorklund, and he said, and he got disbarred. Yeah, he got his license revoked. Not so much maybe for the advertising. He probably could have talked his way out of that. But I mean, that's what got him in there in the first place. And his defense was, well, I can't help it. Yes, the publisher said all these glowing things about me. Yes, they said these wonderful things about me, but what can I about that? They're just advertising their book. Well, that defense might have worked, but as they are sometimes want to do, the Office of Professional Discipline maybe actually did a little bit more research to it, and it turns out the publishing company just happened to have the same address as his law office. Like I say, he probably would have been off a little bit lighter if he had the choice right. But I mean, that was what the offense is for. So as recent as 2006, these provisions were still being enforced, and I cited some other ones here from 1997 through 2001, where that issue was brought up, and the Iowa Supreme Court said that these rules did not violate the First Amendment, at least as they were applied in those cases. Now, like I say, this was never appealed to the U.S. Supreme Court, so it's quite possible that they would have had a little different take on it. Rule 7.3, direct contact with protected clients. Interestingly, even though the advertising law rules here are pretty restrictive, this rule was pretty much in tune with discrimination, with a few little twists. And in general, under both the old rule and the new rule, and the rule in most states, in general, if you know that somebody has a particular legal need, so in other words, you go down to the jail on Monday morning and get the list of people who were arrested. You know that those people are probably in need of an attorney. Well, under all the rules, you are not allowed to solicit those people in person or by live phone contact or real electronic contact. So you can't solicit them in person, or knock on their door, or call them, or send them an instant message. You are, though, allowed to send direct mail to such people. So interestingly, even though the rules were pretty restrictive until January 1st, that was pretty much the same in other states. So you could, in Iowa, you go down to the courthouse and get the name of people who were arrested, or the people who have consumer credit judgments to get them, who need to file bankruptcy, or name that, and you were allowed to send mailings to those people. The restrictions, though, first of all, you had to keep copies for 3 years. You had to write the word advertisement only on the outside of the envelope, which incidentally is how many spouses learn that their spouse was arrested for DUI. And then Monday morning, there's this flood of letters for lawyer in town. They kind of wonder what's up with that. But the other big restriction, which interestingly is being done away with, that seems to me is kind of the only restriction that has a lot of meat to it. You were required, when you sent out that advertisement, send a copy to the Supreme Court, for them to keep on file. Iowa is not maintaining that portion of the rule. So their whatever office the Supreme Court deals with all these ads, they're not going to be doing it anymore. But other states follow the model rules. It's interesting. Some other states still have that provision. So, for example, Wisconsin and Indiana are two states that I'm aware of that even though they follow the model rules in other respects, they have that issue where you have to provide a copy with the state, which well, that probably does more to keep the advertising kind of on the up and up. So those kinds of things will be permitted. But that's an area where it's liberalized somewhat. So here, what are the rules? Well, Rule 7.1 remains pretty much the same. And how it is the same in Iowa, it is in Nebraska, and Minnesota, and that is that they took out the part about unverifiable information and the quality of your services. So you're not allowed to say, I'm a good lawyer, but it can't be false or misleading. Well, Rule 7.2 is the rule that says, yes, you can advertise now. And, I don't even think they have the word dignified in there anymore. It doesn't say anything about non-dramatic voices. It's pretty much wide open. Although it kind of the rule is kind of worded in kind of a little bit of a strange fashion because it starts out basically saying advertising is illegal unless it's legal, but the part that's legal is pretty big because it says you can't give anything of value to anybody to recommend your services. Well, that's exactly what advertising is. You pay the newspaper to print a thing on page A3 saying we recommend, the services of a lawyer are recommended. But the first exception to that is that if it's otherwise permitted advertising, then that would not apply. But what it would apply to, for example, is if you pay somebody other than permitted advertising to recommend your services. So, for example, that's one of the reasons why a referral fee is illegal, because you're paying somebody to recommend services, and it doesn't come under the category of permitted advertising. And also, if you, for example, that would make it a violation to, if you pay OLA to the newspaper reporter to say favorable things about you in the news article as opposed to an advertisement in the newspaper, well, then you're giving something of value to someone to recommend your services. So that would be a violation because that's not a permitted advertisement. That's the news part of the newspaper. So, but you are allowed to pay the reasonable cost of permitted advertisement. Other exceptions of giving something of value to recommend you is if you're a legal service plan and it's approved and it's a nonprofit, otherwise you're allowed to be a member of that. A little later, we talk about Rule 17. There's some special rules about buying a law practice. So if you're retiring from the practice of law and you sell your practice to somebody else as an ongoing business, well, you're generally allowed to do that as long as you follow the rules. But this rule makes clear that that's an exception to the giving something of value to recommend your services, because when you sell a going business, that's one of the things you're doing. You're selling your, when Kate Halton says, will you take my case, you tell them, no, I sold my business, here's the number of new person. That's the exception then to paying somebody to recommend you. Also, it is legal to have a mutual referral arrangement with another lawyer or another professional. So like, a physician or a chiropractor, or an accountant, I will send you patients, you send me clients. That's permissible if, first of all, it's not exclusive, because you have to use your independent professional judgment. So, you normally send your bankruptcy clients to the bankruptcy guy down the street, but if that's exclusive, well, then, the general case walks into your office, well, that guy down the street maybe doesn't have his capabilities. So you can't exclude it. You still be able to exercise your professional judgment. And the client has to be aware of that agreement there. So those kind of things that are not advertising that, that they're kind of in that general category of paying to recommend your services. And that's about all it says, though, about what restrictions are on advertisement. it can't be false or misleading under Rule 7.1. And really the only substantive restriction is that any advertisement must include the name of at least one lawyer or law firm who is responsible for its content. So you can't, advertise anonymously. You can't, so if you just